Thank you, Your Honor, and may it please the Court. Ms. Flynn, Mr. Perry, Mr. Long. Good morning, ladies and gentlemen. I'm going to ask for your indulgence just a little bit longer. I know that you've been patient over these past few weeks. You're very eager at this point to get back to that jury room and actually start discussing this case, start considering the law that the judge is going to give you. And I'm sure there's a lot of things I'm sure you're going to want to say to one another, thoughts to express. You've been very patient throughout this process on behalf of myself and Ms. Flynn, the prosecutor's office, as well as the family and friends of Tim Durham. I thank you for that patience, sincerely. Much has been said in this case and made in this case about the videos. Now, the issue with videos, folks, is that they don't always necessarily, in and of themselves, provide the entire context. There have been many times where we've watched something, seen something, and had to back it up a little bit just to get our mind straight about what's happening. I've done that numerous times myself when watching a movie, particularly films by Christopher Nolan. They require a bit of thinking and a bit of processing as to what's happening in them. You back up a few minutes, rewatch it again and say, okay, now I think I know where I'm at. And as Ms. Flynn stood up here in front of you a couple weeks ago, she asked you to not have a gut reaction, not to have a knee-jerk reaction about what you see in those videos. That you need to take them and step back and consider what is actually going on. Now, personally myself, I prefer photography over videos because my father was a photographer, and his job was to capture moments for people to look back on at a later time so that they can remember what was happening. They can look back and see a loved one that may have passed away, remember the good times that they were having, a wedding that may have occurred, a family portrait that's hanging above a fireplace. You look back and see where you were, what was happening, and the stories about what's in this photograph provide the context of that moment when the things were happening. Oftentimes, folks would bring in old glass plate negatives to my dad that were many times 100 or more years old. You don't always necessarily have the story that goes along with the people that are in that picture, but you can look at it and you can make some inferences about what you see in that image in and of itself. Perhaps you know where the studio was. You look at what the people are wearing in the photograph. You look at what they're holding, if anything, where they're standing, what their surroundings are, who they're with, perhaps the expression that is on their face. As Ms. Long said in her closing remarks, a picture is, frankly, worth 1,000 words. But, ladies and gentlemen, it is your decision, based on reasonable inferences, based on logic, as to what those words are when presented with the photograph. You provide the context to what is happening in that photograph. And those words are based on common sense, reason, and logic. And I want you to keep this image with you throughout my remarks. What is this an image of? Is this an image of a man that is in fear? Is this a man whose life is in danger here? That felt it was necessary to resort to deadly force? Or is this the image of a young man who is angry, enraged, and irate, full of indignation and aggravation? I took note, oftentimes, throughout this case, to the attention that you paid to the testimony as well as the exhibits that were presented. You placed a lot of emphasis on details. Those details help you discern what is in these images. The defendant's anger, for example. The fact that there were no weapons in the possession of the Durham family. Where the defendant was positioned, when he formed the intent to use deadly force, and when that deadly force was actually utilized by him. Now, what myself and Ms. Flynn and what Mr. Perry said up here in his opening, what Ms. Long said in her closing, what I'm speaking to you now is not evidence. It's simply our arguments, our positions. You have to also consider whether or not there's any speculation involved in what is being said here. And the judge is going to instruct you that speculation, conjecture, and other forms of guessing play no part in your deliberations. You look at the defense arguments, is any of that speculation, is any of that based on reasonable inferences? Is what they're saying relevant? You're not to guess what is or what may have been. You have to actually look at the evidence and consider that in and of itself for your determinations. The law does not require that the state overcome every possible doubt, because not all possibilities are reasonable and not all possibilities are logical. Not all possibilities make sense. The question is whether or not it is probable. That's where your focus is. What is probable? What is reasonable? What is logical? Analyze the evidence, come to your conclusions to determine whether you're firmly convinced. Not everything has to be proven by direct evidence. Remember the strength and the importance of circumstantial evidence in a case. It might be more satisfying, more certain than the direct evidence might be. I'm going to say it again. The importance in this case and your determination in this case is what is sufficiently reasonable, logical, and probable. You have to look at each count of the indictment and determine whether or not the state has met its burden in proving beyond a reasonable doubt whether you're firmly convinced of each element of each crime, and also whether or not the defendant was justified in his use of deadly force. This case is somewhat of an exercise in legal analysis. You have to apply the law to the facts. The facts and that analysis with the law is an important and nuanced task that you're going to have to undertake. And when I was first assigned to this case, back in the evening of May 4th of 2020, I thought to myself that, quite frankly, this case could be on the bar exam. This could be an analysis that somebody that wants to be a lawyer would have to go through in order to explain the rationale and the reasoning and how they came to a conclusion in the case. And I know it might sound a little bit scary, but you folks are going to have to kind of think like lawyers here. You're going to have to weigh the evidence calmly and without passion, without prejudice or sympathy of any kind. You have to apply the law as the judge will instruct you to the facts as you find them. And when I started law school about 22 years ago, they taught the IRAC method. IRAC stands for the issue, the rule, the analysis, and the conclusion. The issue, you have to identify the issue presented by the factual scenario. The rule, you have to state and define the legal principle that applies to the issue. Analysis, that's the discussion, deliberations on how the law relates to the issue identified from the factual scenario. And the conclusion is based on the analysis. How do you find actually, and what is your decision? Is it based and is it thorough on what is the law? And that's essentially what your role here is as jurors. You have to discern the facts and identify the issue. The judge is going to provide you with the law. You deliberate, you apply the law to the facts, and your verdict is the conclusion to that analysis. During your deliberations, again, do not hesitate to re-examine your own views and change your position if you believe it might be erroneous or it might be mistaken. Listen to one another and discuss this, talk it over. The issue here, ladies and gentlemen, is whether or not the defendant, the deadly force used by Zachary Latham, the defendant, was justified. That is the issue. But before we get to how the law applies to that, we have to distill the facts. We have to narrow that down and talk about what the facts are in this case. And part of that is your assessment of the credibility of the evidence and also the credibility of the witnesses, the credibility of what you heard and what you have seen. How do you weigh that evidence and how do you determine whether it's reliable and whether it's trustworthy? You do that pretty much the same way you go about making decisions in your day-to-day lives. You hear about something, you learn about the subject, you get the opinions and perspectives on that issue, and you decide for yourself what is right, what is wrong. It's really no different than perhaps, working an argument out between kids or between coworkers and colleagues. You get your positions, you find out for yourself what is correct, what is wrong, and then you make your determination based on all of that. You have to draw on your experiences, you have to draw on your common sense. So what happened back on May 4th of 2020 on Thornhill Road that led to the death of Timmy Durham? Where and when did those events begin? How did they end? It began with the initial unnecessary, dangerous harassment of Gage at the end of the driveway. Now, the defense wants you to believe that this didn't happen, or if it did happen, it didn't happen how Gage said it happened. That Gage was driving out the driveway, defendant comes down, swerves, honks at him, forces Gage off the road for no legitimate reason. Now, they want you to believe that this didn't happen that way because there is no video of it happening. But again, as I stated earlier, if there is no actual video, how do you determine whether or not this actually happened, if it happened the way that Gage said it happened? Look at the credibility of Gage. Did he have an intent to deceive you when he was testifying? Did he have any reason to lie about what had happened earlier that day? There was no motive whatsoever for him to make this up. I think back to my own personal experience, and you may do the same, about when I was a kid growing up in Center City, Millville, near the Wheaton Glass Factory, that my parents would tell me, be careful when you're out in the street. Watch for the cars. I followed their instructions. I didn't get hit. Perhaps you tell your kids the same thing. Perhaps your parents told you the same thing. Watch what's going on. Be careful when you're out there. There are 3 ways that cars could be coming, as Gage testified to. You got cars coming up Bayberry, you have cars coming from the left on Thornberry and from the right on Thornberry. Gage is going to watch and make sure that there's nobody coming to get out into that roadway. Regardless of whether or not that incident actually happened, that ultimately doesn't matter when it comes down to a determination of whether or not the defendant was justified in his use of force. The sole purpose of presenting this to you was to give it context, to explain what sparked the events of that day, what transpired earlier in that incident that led to ultimately the face-off between the defendant and the members of the Durham family. Legitimate or not, it's very telling about that engagement at 2900. If you look at the defendant's reaction and the attitude of the accusations that were being levied against him, the defendant here is defiant. He is arrogant. There is no fear in his face. There is no concern on his part whatsoever. Throughout this interaction, he minimizes the conduct until he is advised that, wait a minute, there might be a video. Once he's advised that, oh wait, there might be this video, he acknowledges, oh yeah, something did happen. And yeah, I honked at him. He admits to it at that point. And then, okay, well, yeah, I honked, but I didn't hit him. Well, he was never accused of hitting anyone. And then when he starts putting words into the mouth of Tiffany, saying that, well, yeah, she said that I hit him, that's what sets it off. His continued, repeated lies about what he actually did from his perspective. And then once he's confronted with those lies and the false accusations that he was making, he does this. Now, whether he was just trying to get the cell phone out of the way, there was no reason for him to place his hands on Tiffany at that point. There was no reason for him to push her out of the way, for her to fall back onto the road. Think about the perspective that Tim and Billy and Gage had at this point. From their perspective, based just on this, their wife and their mother had just been assaulted. In addition to the inappropriate, unnecessary, and dangerous harassment of Gage earlier that day. Now, could the dorms have acted and reacted in a different manner? Certainly they could have, but we're not here to try to justify their actions. We're not here to try to excuse their conduct. It's highlighted again to explain and to give context to the situation. Should they have marched down to the defendant's house? No. But at the same time, was the defendant reasonable in his reaction at that point? Was he reasonable in his use of deadly force? Was he reasonable? Was it necessary? Was it legally justified? It's the state's position that it was not. When you look at the credibility in this case, look at the defendant's own words and analyzing his state of mind. Use his words to analyze his state of mind as to what happened down at 2986 Thornhill. When you look at his statements and you look at all of them and take them in context as a whole, what, if any, truth is there throughout his version of events from the evening of May 4th up to when he's interviewed at the Bonneville Police Department the next day on May 5th? It is full of distortion and deception from that moment at 2900 up to when he gives his interview. If he has an honest and reasonable belief that deadly force was appropriate and necessary at the time, there would be no reason to alter the facts, no reason to provide a different version. The defendant's lies, again, started at 2900 Thornhill. And yes, the end of that video that Ms. Long played for you doesn't give the full picture. Because when they are driving away from 2900 down to 2986, call the cops, tell them they assaulted, and then it breaks off. You've seen the videos, you've seen the still shots. You know the context of that interaction at 2900. Was there an assault? The defendant at that point is upping the game. He is upping the interaction. He is making it more than what it was. When he calls 911 after the incident happens, there were 10 of them. They came on the property with guns. You've seen the video. You know the context. There weren't 10 of them. They did not come on the property with guns. No weapons, nothing in their hands. In that 911 call, he mentions the garage. But minutes later, that changes. When asked if he needs an ambulance on the 911 call, he's equivocal. He's ambivalent about it. He doesn't say that, yes, I immediately need an ambulance for myself. When you look at the body-worn camera footage from Officer Rodriguez and his interaction with the defendant, he expands his lies. He expands his upping of the game. His story changes at that point. At that point, it's moved from the garage to the kitchen. When you look at the pictures of the garage versus the pictures of the kitchen, it's clear where this took place. It started outside the garage to the inside of the garage. And I'll get to a little more about what happened inside the garage as I move on. But when you look at where things took place, it's clear the defendant was trying to legitimize and make it sound as though he had an honest and reasonable belief when none ever existed. There is nothing substantiating that claim. Nothing was out of place in the kitchen. You heard the testimony of David Prestis. And when he came downstairs, the defendant then came into the door, and there was some blood left on the edge of the door. That was cleaned. That's all that was cleaned. There was nothing that happened in the kitchen. Also, in his statement to the EMT, he mentions his head getting bashed in the kitchen table. I don't know which table he was talking about, whether it was the center island or the eat-in table right there in the kitchen, but any evidence that anything is displaced, moved, anything of any consequence happening in the kitchen. This is what the defendant says, and I want you to pay attention on how he says the words he says here, and then the sequence that happens once he responds to the EMT's question.
All right. What's your last name?
Laidlaw.
How do you spell it,
L A T H
buddy?
H
H
A
A
L.
N. What's your date of birth? What's your date of birth, buddy?
April 20th,
April 20th? What year?
2002.
Okay. What's your address, buddy?
29 86.
86 Thornhill?
Yeah. It's hard to talk.
Okay.
What's going on? I can't see straight. My whole body's numb. Every time I swallow, it hurts. I got stumped like 20 times. And he bashed my head in my kitchen table.
Think about how the defendant says his words. He's asked what his name is and how to spell his name, and he portrays as though he has difficulty doing so. That he can barely get those words out. But then, as soon as the EMT says, "Hey, what's going on?" he's able to rattle off, one by one, his version of what happens. Is he honestly and reasonably remembering or having difficulty with his name? But he immediately says, "This is what happened. This is my concern. This is what's going on." Clearly, folks, he is upping the deception at that point as to what was going on. Earlier in the video, he says he has trouble talking here. But earlier in the video, I forget exactly how many times it was, but how many times he yelled, "They came in our effing kitchen." Yeah, because they came in our effing kitchen. He is yelling those words at that point. But yet he has difficulty talking and difficulty speaking. He mentions the kitchen no fewer than 7 times during the course of that interaction with that body-worn camera video. And once we get to the Vineland Police Department the next day, he continues those lies. At that point now, himself, Sarah, Dylan, and Moses are now all in the garage together. At that point, the Durhams come running up the driveway. At that point, they storm the garage with everybody inside. He has to retrieve a knife at that point while everybody is inside the garage. Tim follows him into the kitchen, at which point he flails his arms and slashing at his arms in order to try to get him away, necessitating him to repel Tim. And also at one point, he is caught in a lie.
I didn't know I cut him the first time. Like, I don't recall having a knife in my hand.
Outside the garage?
The first time. Because I know for a fact I cut him in the garage.
Where did you cut him in the garage? Not like
in the kitchen.
it's like on his body.
I mean in the kitchen.
He mentions the kitchen during that interview more than 25 times. He mentions threats to kill that were made to him, down to 2900 and again in 2986. You've seen the videos, you've seen the photos, you know the context. There were no threats to kill at any point made to him by any member of the Durham family. Was there anything really that was said that is on par with the evidence in this case? When confronted with the prospect of the video, he suddenly recalls the gaining of a second knife. I don't know where that came from because, as testified by multiple people, there was only one knife that was recovered, that is S31, which is in evidence. And throughout the defendant's stories, from the time that they left 2900 to the time they got down to 2986 to the time that he gives this interview with the Vineland Police Department, so many things are just not the case. There was no confrontation in the kitchen. He does not kick Tim down the steps. His grandfather doesn't come down to break up the situation and pushes people out of the way. Everyone was not in the kitchen. Everyone did not come down together in the truck. There was no grabbing of the ignition or attempt to grab the ignition by Catherine when they're down at 2900. That is all things that are made up by the defendant in an effort to show an honest and reasonable belief that deadly force was necessary when that honest and reasonable belief was never there. This deception, the distortion, does not equate to an honest and reasonable belief. The law is going to come from the judge. And you have to consider the judge's instructions in their entirety and not pick out one thing in particular and focus on it. You have to look at it as a whole and look at it in context. And when we began this case, Judge D'Arrigo asked explicitly whether or not anybody would have any difficulty in accepting the law as he will be instructing and applying the law to those facts, regardless of what your belief may be. Now, I discuss my work and my cases pretty often with my wife. And oftentimes we start discussing what the law is and what the criminal code says, what the rules of evidence are, what search and seizure case law is. Now, my wife is a smart, intelligent, and educated woman. However, she's very opinionated. And those opinions cannot easily be swayed. I've tried, I succeed very little. While she would be a terrific lawyer, she would not be a good juror, unfortunately. Because while her personal thoughts and feelings are well-reasoned, rational, and intelligently made, it's contrary to what the law is. So you folks, however, are jurors. You said you're able to follow the law. You can apply the law to the facts. That is your role. That is your duty. One of the things the state must prove is whether or not the defendant acted recklessly. Now, much comment has been made about this case from the defense perspective about the size of the men of the Durham family, how they are big and capable men. Compare and contrast who the defense describes and who you saw as witnesses in the case. Not to offend, but is Gage big and capable? Was Billy, his demeanor, that of a big and capable person? When you saw the photographs and the description that were provided by Dr. Williams, was Tim big and capable? Now, the defendant in his statement compares Lieutenant Breslin with how big Tim was, but you saw that for yourself. As far as the question of size, the real question really is capabilities. And the defendant, I would suggest, ladies and gentlemen, was quite capable himself. As you heard in his statement, he has had military training. He's in the National Guard. He went to basic training. He was trained in hand-to-hand combat. When it comes to recklessness, the defendant had been taught about how to defend yourself. If you need to defend yourself, what you're going to be doing, how to use that knife, how you're going to interact with somebody in a situation. He was fully aware the manner in which he used the knife was capable of causing death. Now, we're not saying that it was his purpose to kill Tim. That's not his purpose. But the manner in which he used the knife was reckless on a multitude of levels. The defendant was not panicking. He was thinking clearly. He was reverting to that muscle memory that he had received in that training. So when you compare the knife that was used, S31, and compare that with the injuries that the victim received, the deep gaping incised wound to the right arm, stab wound under the armpit to the left side of the chest, going 5 to 6 inches into the chest cavity, piercing his lung. Both of those injuries capable of causing death. The defendant was not simply just swiping the knife. He was not simply swatting at the victim. He knew exactly where to strike and how to inflict the injury. Under the circumstances, a reasonable person would not have acted as the defendant did. The defendant attempted to cause serious bodily injury to Tim and also Billy. The defendant was the first one to swing, narrowly missing Billy. There was no punch by Billy at this point, and the defendant slicing the arm of Tim. As Dr. Williams said, without medical treatment, that would have caused his death. As I've said before, and the judge will tell you again, it is the state's burden to leave you firmly convinced whether or not the use of force was justified in this case. There are two standards that the judge is going to describe for you. One is use of deadly force, and the other one is use of force against an intruder. On the use of deadly force, what you have to look at is whether or not the defendant had a subjective belief that deadly force was necessary on the present occasion, and whether the exercise of that force was objectively reasonable. Would it be reasonable, when you look at an honest and reasonable belief, if a person was in immediate fear of death or serious harm, that they would enter their home, grab a knife, and then to come back out for a confrontation in what is subjectively a tense situation already? Or would it have been reasonable to do as the defendant suggested in his ride back to his house? Call the police. Everyone had cell phones, the defendant says in his statement. Everyone had cell phones. He had a cell phone, Sarah had a cell phone, Dylan apparently had a cell phone, as did Moses. Did anyone feel it was necessary when they got to 2986 to call 911? If you have an honest and reasonable belief, that's the time to give them a call. It's also anticipated that the judge is going to instruct you that the state can disprove the use of deadly force in a number of ways. First, as I have been already saying, that it was not an honest and reasonable belief on the present occasion. That the defendant provoked this incident with the purpose of causing death or serious harm. That the defendant could have retreated with complete safety. And if they are intruders, that the encounter was not sudden and not unexpected. Now, there's no need for all 12 of you to agree which part of that self-defense the state has proven beyond a reasonable doubt. 3 of you can believe that the defendant did not have an honest and reasonable belief. 3 of you can believe that the defendant provoked the incident. 3 of you can believe that retreat was an option. 3 of you can believe that the event was not sudden and not unexpected. In assessing this, you have to assess whether the self-defense is credible. Take the defendant's version for what it's worth. Take it for what it's worth. Is it contrary to what the evidence is in the case? The lies, the time, the driveway, nearly the entirety of everything that happens, the defendant tries to legitimize his use of deadly force. If it's honest and reasonable, he would not have lied. If he didn't provoke the incident, he wouldn't have lied. If he could have retreated, he wouldn't have lied. If it was not sudden and not unexpected, or if it was, he wouldn't have lied. It's a saying attributed to Mark Twain, that if you tell the truth, you don't have to remember anything. Look at the events of May 4th and break them down and analyze them. The timing, the defendant's plan, the defendant's choices, when those choices were made, his choice to use deadly force, when that was formed, when he pulled in the driveway at that time, right before the dorms even were within eyesight of the house. When you look at the beginning of the video that Sarah took from 2986, The defendant at this point was already in the house. No indication from anybody, from any source, that anybody from 2900, any member of the Durham family was on their way. No indication at all. But he knew exactly what he was going to do at that point. He knew exactly where he was going to go in the house, what he was going to get, where he was going to go after getting it. And he didn't just get any knife, any knife that he could have grabbed out of a drawer. He got a 9.5-inch knife with a 5-inch blade. He didn't say a word to Sarah. He didn't say a word to Dylan. He didn't say a word to Moses as they got down there. If he had an honest and reasonable belief, he would have gathered everybody in the garage like he claimed he did in the Vineland police statement. But he never did. At no point did that happen. Now, the defense here suggests that the encounter at 2900, that Tim said the words, "Get him." Remember, it's your determination and your recollection of what controls here, not the suggestions that are made to the witnesses on cross-examination. So let's listen carefully to what Tim says.
You're 18. You're 18. You're 18. You're
Did he say, "You're 18, get him"? Or did he say, "You're 18, yeah, come on"? It's your recollection that controls here, not the suggestion of either myself, the defense. It's what you hear that matters. Regardless of what he says and how he says it, the question is whether or not there's an honest and reasonable belief that his safety is in danger. If it was, he wouldn't have left his wife and his friends out in the driveway. It wouldn't have happened moments later. It would have happened immediately. If it was an honest and reasonable belief after that interaction at 2900, he wouldn't have stopped at his house. A reasonable person perhaps will continue by their house to get to safety. They would have called 911. They wouldn't have stopped 500 feet away. The other people that were with the defendant that day, Sarah, Moses, and Dylan, again, they saw what happened at 2900. They didn't feel the need to do anything once they got back to 2986. When Gage and Billy got down to 2986, Sarah, Moses, and Dylan didn't do anything. While the defendant was inside getting a knife, Sarah pulls out her cell phone. She doesn't call 911. She pulls out her cell phone and records. If this was an honest and reasonable belief, the defendant would not have come out of the house. Because it's not honest and reasonable, the defense fails. There is no proper use of force. Even if, supposedly, the defendant had an honest and reasonable belief, you have to look at whether or not the defendant provoked this incident. Where were Billy and Gage at when they arrived on the bikes? Where was the defendant at that time? The defendant was inside the house. What purpose would you have in coming back out? If not to provoke, if not to continue this engagement, this interaction. The words spoken by Sarah when Gage and Billy first arrived are very telling.
I promise you better back up because you're not going to like what's coming out.
What's a reasonable inference to that? What does your common sense tell you? What was the defendant's purpose at that time? To continue what had happened. What's his state of mind like? The defendant provoked Gage, Billy, and Tim at that point. The defendant initiated that aggression with the knife and the stun gun. The defendant wanted this encounter to continue. Otherwise, he would have stayed in the house, he would have secured the castle, he would have called 911 and gotten back up there. Billy testified that he only went up the driveway because the defendant came out with the knife with the stun gun. The defendant provoked the incident. The defense fails. If there is an honest and reasonable belief, if the defendant didn't provoke, he still could have retreated. Mr. Perry, in his opening remarks to you a couple weeks ago, said that escape is the safest option. That option was there. The defendant did not have to come back outside. He could have reasonably gone into the garage, closed the garage door, gone into the kitchen, locked the kitchen door, and called 911 like he said to Sarah on the way down to their house. We know that the garage door opener was right there by the kitchen. We know that it worked, according to David. We know that there was a cordless phone available as well, so in actuality, perhaps there were 5 devices that could have contacted 911 when the defendant got back down there. But yet there was no need to come out with a knife at that time and to confront the Dorans. No legitimate reason. It was the defendant's choice, the defendant's decision to continue the confrontation at that point and to leave the protection and safety of the dwelling. Now, the judge will likely also instruct you on use of force against an intruder. Were the Dorans intruders? Were they going into the dwelling? Was that their purpose when they got there? If it was only after the defendant inappropriately used deadly force against them. The initiation and the display of that use of deadly force beyond the threshold in the defendant's driveway. The judge will define for you what the law is regarding the duty to retreat and also what it means to be an intruder in a dwelling. The threshold is part of that dwelling. But it's for you to determine what that concept is. The law draws a line at dwelling, at threshold. You determine the concept of threshold under the circumstances. Beyond that threshold, deadly force is not justified. The Dorans were not intruders until that show and that display of deadly force was utilized by the defendant. Regarding whether or not this was sudden and unexpected, the defendant kind of goes along with provocation. The defendant was fully aware of what his actions were going to be. He was fully aware that his conduct was likely to engender a response. This was not a sudden encounter at 2986. It was not an unexpected encounter at 2986. The defendant retrieved the knife and he came back out with the purpose to cause death or serious bodily harm. And recklessly caused death. When you look at the events of this day, and you start here at 2986 with the cell phone video that Sarah took, and you go to this point here where the defendant used deadly force, that's about 33 seconds that take place right there. At the beginning of this video, no sign of the Dorans. They're nowhere in sight. The defendant is inside arming himself at that time. 33 seconds later, the defendant uses deadly force inappropriately. Think about that 33 seconds and what the defendant did, what his actions are. He goes between the cars that are in the garage, over to the steps that lead up to the kitchen. Goes past the garage door opener at that time, through the door into the kitchen, over to the center island. Opens up that middle drawer, grabs a knife. Somewhere else in the kitchen, he grabs a stun gun. He then leaves the kitchen, through the doorway, past the garage door opener, down the steps, between the cars, past the threshold of the house, past the threshold of the garage, past the threshold of the dwelling, finally to the driveway. Now, 33 seconds may not seem like a very long time. Let's pause for 33 seconds, starting now. I was actually a little shorter then. But however, regardless, ladies and gentlemen, the encounter was not sudden. The encounter was not unexpected. The encounter was the defendant's decision. The use of force was not honest, it was not reasonable. If it were, he wouldn't have lied. He would not have lied about the interactions at 2900 and what was said. There were no threats. He would not have told Sarah to call the cops and say that they were assaulted. He would not have lied about there being guns. He would not have lied about the sequence of events at 2986 and gotten everyone into the garage at that point. He wouldn't have been unable to, when he lied and said he was unable to put down the garage door. When you look at the fighting that in the garage, there was no gun that was present. There was no attack inside the kitchen. He would not have lied in an effort to legitimize his actions. The defendant provoked this incident. It was his decision to get the knife. It was not necessary to go outside. The decisions by the defendant were reckless. The decisions by the defendant caused William T. Durham Sr.'s death. Soon the 12 of you will deliberate. You're going to have 12 different walks of life, 12 different sets of eyes, 12 different sets of ears, 12 different life experiences. Each of you has the ability to decide for yourselves what is right and what is wrong. You've heard the testimony, you've listened to the opinions and perspectives. You're going to apply common sense and logic. You're going to make reasonable inferences, and then you're going to come to your conclusion. You'll sit together, consider the evidence, determine the truth, and come to a just verdict. Ladies and gentlemen, I submit to you that based on the evidence, that the verdict is guilty of reckless manslaughter, aggravated assault, possession of a weapon for unlawful purpose, and unlawful possession of a weapon. Again, I thank you for your attention this morning, and I wish you luck in your deliberations.
Thank you, Mr. West.